as I mentioned earlier, perfect. This is going to be an interactive event. If you'll notice on your phone, if you scan this, it will show you polls or questions and answers. These are anonymous unless you choose them to not be anonymous. So they start out anonymous. So if you want to add your name, you're welcome to. Otherwise, what you put in is just being part of the interactive conversation here. Okay. So let's get started.
Perfect. Thank you, Kate. So we'll start by talking about who we are, so you're comfortable with the information we are providing. We've been in the industry for 50 plus years, and we're really focused on the regulatory multi-state populations with an emphasis on safety-sensitive populations. So the same standards we apply to safety-sensitive populations, we apply to everyone, so everyone is safe. We are also nationally accredited and have zero litigation against us. We also offer compliance expertise. And as a fun fact, we are the only firm that has been ranked as a top enterprise screening firm 14 years in a row in a client survey, in a client-based survey. And this is kind of like the Oscars for background screening. So very exciting. And I'm also proud of the fact to say that 2 weeks ago, it was announced that we won as the #1 background screening firm over all the background screening firms for 2023. And then some challenges with screening. What we want to do is really talk about all those challenges of background screening. And there are many challenges as onboarding a new candidate to make their start date has become a much more challenging process due to things like fair chance, ban the box laws, ban the box regulations, really people wanting to have credentialed job offer. There are court delays due to limited court staff. There are verification delays due to third-party agencies. And limited information that causes more delays. Also, candidates and requesters that want easier and faster process to onboard, which we, of course, understand. And then post-COVID, the international searches, we've seen an increase in turnaround time as well. And also the adverse action process, this can also cause delays, which we'll get into later on during this presentation. So what are the best ways to reduce these roadblocks? Kate will speak to that in a minute.
Okay, so just one more kind of housekeeping thing. We're going to have a Q&A session at the end. You can enter Q&A on the phone, different questions and what have you, but we'll have a full Q&A session. I think it's better to do it at the end. All right, so who audits consumer reporting agencies? So consumer reporting agencies are background screening firms, not just your credit bureaus. The Federal Trade Commission, which was established a long time ago, back in 1914, was established mainly for the banking industry to make sure that everyone had fair rights and was able to get credit and actually do business. They established the Consumer Financial Bureau, the CFPB, in 2010, and they are really more specific for consumer protection in the financial sector. And the EEOC is the federal agency that administers and enforces civil rights laws against workplace discrimination. So what's interesting is that in November 2022, the CFPB reported that screening firms have failed to conduct reasonable investigations of consumer disputes and to spend the time necessary to resolve inaccuracies. So litigation is going to be increasing. And then as early as September of 2023, according to preliminary data, the EEOC filed 143 new employment discrimination lawsuits in the year 2023, responding to, which is more than a 50% increase over 2022 suit filings. So it's really important to understand that, excuse me, litigation is definitely on the rise. Under federal law, the Fair Credit Reporting Act is what sets the standards for the CRAs. And the FCRA, the Fair Credit Reporting Act, was passed back in 1970. It was amended a couple times, 1996. And then in 2023, it was amended by the Fair and Accurate Credit Transaction Act, FACTA. So as federal law, it applies to everyone. However, it's one of the few federal laws where states have become more stringent, and many states have. So we'll talk about that. In addition to the federal law that applies to everybody, depending on the state, you may see a much more strict compliance and regulatory arena when it comes to screening. But the act as a whole, it's designed to make sure accurate information is reported. It's going to restrict and limit the information that is reported. And then it also provides a dispute mechanism for consumers. So it's about making sure everyone has the information that they need, but at the same time, to make sure that discrimination doesn't happen on information that may not be necessary at this time. So the question comes up a lot, well, why don't I just go online and do it myself? In today's world, the internet definitely has a lot of resources. However, many of those online services are not consumer reporting agencies and don't comply with the FCRA. Back in the day, you'd find that statement, you know, in about 4-point font at the end of the whole thing. But because of lawsuits, you're now seeing it much larger. So you'll see a notice, you know, you can find out information for entertainment per se, but is not to be used for employment purposes. This becomes even more risky using this source as it relates to clean slate acts and other information that you may be seeing that you ought not to be seeing. We'll talk about those laws in just a moment here, but just know that in July 2022, there was a lawsuit because the plaintiff claimed that the employer used an online firm, made a hiring decision, but they didn't follow the FCRA. The EEOC is the agency that came up with guidance factors, which is the idea of when to hire or not hire based on information on a report. We get that question a lot. Hey, this person's got a misdemeanor. It's, you know, X amount of months ago or years ago. Can we hire them? Should we hire them? What do we do? This link, and by the way, you'll get all these slides and they'll have all these links for you. This link will be really, really helpful. I found on the internet, as I'm sure most of you have, it's a great source of information, but it can take you a long time to find what you're looking for. So what's nice is, again, these slides will have all the links. But this EEOC guidance factors, first couple pages is the legalese, you know, writing the law. But it's one of the few documents that I've seen. They've actually provided scenarios like, you know, Mr. Smith was arrested 4 times for child molestation. He applied for school, hire or don't hire. And they actually tell you. So again, it's very interesting and provides much more information. You'll also always, of course, want to contact your legal. But the basics for the EEOC says this. When you find criminal history, you're going to want to look at the nature and the gravity of the offense. Is it related to the job that they've applied for? How severe is the offense? How long ago was it? And is the person a repeat offender? That kind of sums up the considerations that the EEOC says you should make before you make a decision not to hire. It definitely came out with a no blanket policy, a no hire rule. A lot of times back in the day, you'd see minimum standards is if you're convicted of a felony, please don't apply. You know, that kind of thing used to be an advertisement. That's long since gone. So again, you can't put anything in there that says if you have criminal history, you will not be hired. And the way to reduce risk in this arena is you want to make sure you talk to your legal and have a program in place. Every report needs to be looked at on a case-by-case basis. And then you want to make sure that it's standardized, but not have that blanket rule. So whatever that standard might be, this criminal offense this long ago would be a no hire, and then apply that across the board. Another area where we see risk is that lack of training for the people that are making the hiring decisions, especially if you're a large organization. You want to make sure that everybody's on the same page as to when to hire or not hire, so that a different standard isn't applied to 2 people for the same job classification. And important to know, the EEOC guidelines was created by the EEOC, but it's supported and enforced by the Fair Trade, the FTC, and the Consumer Financial Protection Bureau. Another question that comes up is it okay? And we've been asked to adjudicate, which means a company wants to give us their standards, and then we make the decision, hire, don't hire, pass, fail. This has definitely been an arena for lawsuits, and it is not a best practice. So it's important that your screening firm should not be scoring or grading reports for you, that the final pure determination is by the end user, which is you as the employer. And these are just some of the cases. It's coding's just as simple as fail or no hire or ineligible. All of those have been deemed as a decision made outside of the employer, and therefore it's been subject to lawsuit and litigation. So next steps is you want to talk to your legal about the best practice for reviewing each candidate. You want to make sure you review the candidate's entire report. You don't want to adjudicate with a blanket policy like a felony, so no hire. And then you want to make sure you have clear and accurate training of the adverse action process for your hiring team. And we'll go into that adverse action process in detail in just a few slides here. So take out your phones, got a quick little Slido question for you here. When you talk about class action, I think it's important to understand how big the class is and who's in the class, right? So the class would be Americans that have criminal history, right? So, excuse me, how many Americans, according to the U.S. Department of Justice, have a criminal record? How big is this class? 25 million, 50 million, 100 million? Let's see what we see here. 57% thinks it's 25. 1375, 100 million at 30. 33. Oh, we're splitting it up pretty good here. One more second. And the answer is 100 million. That is a very large class. Basically, according to the U.S. Department of Justice, 1 in 3 Americans have some sort of a criminal history. So you can imagine how big that class is and why the lawsuits are in so much of the are so large. Another reason why class actions are on the rise is the laws have become very, very fragmented. And that makes it very difficult for you because I mean, it's hard enough to keep in contact with the federal level and the state level. But now individual municipalities and cities are also coming up with their own regulations. So it's just makes it very, very difficult for you. For instance, in Los Angeles, excuse me, they have their own form when it comes to hiring. So it's just, again, really important that that you make sure that you're following all the rules and regs for depending on where you live, not just federal and state. Another reason why they're on the rise is money. Excuse me. Under the federal law, there's up to $1,000 per person on these class actions, and add on attorney fees and then damages, and there's no cap to the damages. So our largest one ever seen in all the years I've been doing this, Spectrum got hit and the jury awarded $7 billion, that's a B, $7 billion, because one of their installers went in and actually ended up murdering the client. It was appealed as far as the jury settled or the award. They got it down to $1.1 billion, but that was one person, one employee in one place. So you can see when these lawsuits come up, it definitely gets more attention, and then you start seeing advertised on the internet even. Have you recently been denied for employment? Has any of this happened to you? So here's, I'm not going to go through all these cases in depth, but here's just some of the cases that came up. Again, you can click on and read about them, but $4 million because they didn't get authorization of background checks. And this was 1.1 billion that I told you about Spectrum. $4 million because it had inaccurate criminal information on a report. 950,000 because there was extra information on the disclosure forms, and it wasn't just solely the disclosure. We'll go into those requirements again in the future here. This one didn't $600,000 because they didn't give proper disclosures, and 15 million because the information was outdated in the background report. So again, it's just really important that you are aware of the different cases that are out there. And just to show you from 2010 to 2020, it like 5 times has gone up. These are the FCRA complaints. At the end of 22, the Consumer Financial Protection Bureau said, hey, we are seeing there's too much junk data in these reports. We're going to start surveilling it. This was in August, a couple months ago. They said, we're going to start really watching this. As far as the Consumer Financial Protection Bureau, their cases have also climbed tremendously. What's kind of cool about this is, and again, I'll share this link with you, but you can actually go in and see the reports, see what the complaints are. So there, it now has 4.2 million complaints in that bureau. Pleased to say Universal has none of them, but you can go in and actually search your company and see if there's any complaints against them for misinformation or wrong forms or things along those lines. Another hot topic is pay transparency and salary verification restrictions. 29 states have bans where you can't ask that information. It's aimed at protecting pay discrimination by not allowing you to ask those questions up front. So it prohibits an employer from relying on an applicant's pay history to set the compensation. And it prohibits an employer from taking disciplinary action when an employee discusses how much they're making with a coworker. Okay, so you're not allowed to penalize anyone for talking about how much they're making. California law, employers cannot seek pay history, and even if the information is already known, it can't be used to determine pay or to screen applicants. And employers must give applicants pay scale information if they request it. Again, here's some lawsuits that cover this information. Denton County, Texas, $115,000 to a female doctor because they ruled that they were in violation of the Equal Pay Act. January 2019, this was Maryland, and they paid 3 female fraud investigators lower salaries, and they had to go back and make compensation in that regard. But the most recent case was in 2023, and Texas agreed to pay $46,000 in damage to settle a discrimination suit because it was filed by the EEOC. Again, they weren't following the rules. And just basically across the board, pay transparency is a trend you're going to see more and more of. You want to make very sure that you are following the rules and not asking about that up front, and have standard pay across the board. Medical marijuana laws. I know this is also a super hot topic because, and I am here in California too, so we have different laws. California, Nevada, excuse me, New York, New Jersey, all of them have passed laws regarding medical marijuana. I think it's interesting to note that the drug test that came back post-accident positive for marijuana has gone up tremendously from 2012 to 2022, 204%. So it's obviously a problem, and it becomes difficult for you as an employer deciding, so how do I navigate this and keep the environment safe still? I think it's important to note you are still allowed to have a work-free workplace. Okay, you can have a no drug zone in your work. What you can't do is test for the non-psychoactive cannabis metabolites. Sorry, you can't test for that anymore. So, and you also can't prohibit off-site usage of marijuana when it's recreational. So effective January, a couple weeks from now, Assembly Bill 2188 makes it unlawful for employers to discriminate against applicants that use off the job and away from the workplace. And then just to show how this law is expanding in New Jersey, they prohibit employers from rejecting applicants for testing positive for marijuana. And they actually have to have a workplace impairment recognition expert, a WIRE expert, who's certified to be on site to be able to identify someone who is actually under the influence of marijuana. California hasn't gone that far yet, but it's definitely important to note testing that is different now than what it was before this upcoming law change 2188 in January. We'll talk about those tests in the Q&A at the end if that's a topic for conversation. But basically, here's what SHRM says. You want to make sure that you create clear policies advertising employees that cannabis use during work hours, including meal breaks and rest breaks, is not permitted, and that cannabis use is not permitted on the company premises, including locker rooms, cars, parking lot, nowhere. So you're allowed to still have that as a rule. And then employees who are in safety sensitive jobs should be requested to refrain from marijuana use at least 6 to 8 hours prior to starting work to make sure they can perform their job duties safely. These are really helpful links across all the different states and what the laws are. So you can click on these links and again, get additional information for your particular state that you're in. Okay, ban the box. So ban the box laws, fair chance laws, clean slate laws is kind of become a progression. So remember we talked about not being discriminatory about someone who has criminal history. Well, ban the box is the law that says you can't ask the question on the application. Okay, so back in the day, it used to be convicted of a felony, and then, well, felonies can be wobblers. So if you've been convicted of a felony or a misdemeanor, then it switched to have you been convicted of a criminal offense? Now it's take it off. So over 150 municipalities, 37 states and DC prohibit the question in the public sector. And then 15 states, 22 cities, counties extend the law to private employees. The laws now have penalties. They have teeth if you don't follow the rules and you have that question that are asked. December 2021, federal law prohibits most federal agencies and contractors from requesting information on a job application, arrest or conviction until a conditional job offer has been given to the applicant. So the ban the box is basically talking about not asking the question on the application. Okay, so and it also determines at what point can you ask that type of question. Clean slate laws, on the other hand, are laws requiring the agencies to remove or seal information based on whatever guidelines that particular state has come up with. So Michigan, Oklahoma, New Jersey, California, all these states have set standards that they feel is appropriate that you shouldn't even be able to see the information. Excuse me. So it's supposed to be certain crimes, but with everything, when they come up with these laws, there are outside things that happen. For instance, Franklin County accidentally purged 80% of the records, including murders and rapes and things. So again, it's just know that you're going to hear more and more of things where things aren't reported, which gets back to the searching things online, because I've had clients call and say, hey, we call it a perceived miss. They'll call up and say, hey, we found out that this person had this criminal activity and you didn't report it. And then it's like, well, okay, yeah, you Googled it, but it was 8 years old. You're in California. We're not allowed to report it. You shouldn't be seeing it. You know, so you have to kind of be careful as to what you expose yourself to in social media. There are social media searches out there. We have them, other companies have them, where you have a third party that reviews the social media for you that will help protect you from seeing things that you shouldn't be seeing. But be aware, this is definitely an area for risk, so you want to be careful. And not only are organizations, companies getting in trouble or have risk for seeing things that they shouldn't do or considering them, but there's actually a lawsuit against the New Jersey State Police because they didn't clear it out fast enough. So there was a lawsuit because they had 50,000 records. Some of them had been more than a year old that shouldn't be there anymore. So just know it's going across the board. And again, for clean slate, we talked about what the laws were up here with ban the box. With clean slate, it's definitely the trend. There's 60 bills across 19 states and Washington, D.C. For 2023, you know, so just know that it's definitely a trend that you're going to see. But we're here in California, so we're going to talk a little bit about our California fair chance law. A lot of it is the same as it was before. There's just some extra things that, extra steps that have come into play. What I am very happy about is this is one of the few times that they've actually given you huge tools to follow the rules. Okay, so let's talk a little bit about what this is. So the things that remain the same is employers are still prohibited from requesting and using criminal history until you do a conditional job offer. You still can't put in a job advertisement that a person with a criminal history shouldn't apply. And unless there's some extenuating circumstances, and if an individual happens to volunteer that they have criminal history, you can't use that information until you make a conditional job offer, okay? Where it's changed is this. So that's all the EEOC steps we were just talking about, right? Under federal law, you have to follow the adverse process. Well, now California has their own adverse action process. Illinois has their own too, by the way. They're doing they have a separate set of hoops that you have to go through. I will say California is definitely more detailed in that it requires that you have to do an individualized assessment prior to making a decision as to whether or not adverse action will apply, okay? And then if you do decide adverse action applies, then you have to follow the federal laws in addition to the California state laws. So basically, when you do the individual assessment, you're going to consider, again, the nature and the gravity of the offense, the time that's passed since the offense or conduct has happened, or the completion of the offense. That would be if they were in a diversion program or something along those lines. And the nature of the job held or sought. And does that offense apply to or have an impact on the job that they're applying for? Okay, that's what the whole assessment is. Okay. So the regulations now require an employer to conduct an initial individualized assessment before sending the preliminary decision. It's similar to the FCRA, but it's different as California, saying that adverse action may be taken, okay? The preliminary decision notice still has to identify the offense that's potentially disqualifying, include a copy of the conviction report, give them a copy of the report, and any other document that includes information about the conviction history, a notice of the rights to respond before the employer makes its final decision, and then the applicants have at least 5 business days from receipt of this notice to respond. I'm going to hop up here really fast just because this is so much information and it just sounds like, oh my gosh, what does all this look like? But this is very cool. So I'm going to go ahead and open up this link for you. So what's nice again, as I mentioned, that California has actually provided the forms for you. They've a step-by-step, 1, 2, 3, 4, 5. And then when you click on it, it gives you a conditional job offer. It's in English and Spanish. The initial assessment is a fillable form in English and Spanish. So you can actually just here fill out the form and send it in. So again, I just think, you know, I understand they're trying to protect rights. And in and of itself, it makes sense, but I'm just really happy that it's not reasonable, because when they write laws and they're not specific, it's very difficult to follow. And the fact that they have given very specific dates and times takes out all the questions. So again, that's basically the fair chance law. There are different timeframes that apply just to California when it comes to this, and all that is in that process. Okay, so moving on to what the different forms are.
Yes. So another way to reduce risk is to make sure you're using compliant forms. So we'll start by talking about the disclosure and authorization forms, which are really forms that would be running a consumer report and or an investigative consumer report on the candidate. You want to make sure that these forms do include federal and state compliant language, because certain states like California have their own language in addition to federal laws. You also want to make sure that there's no extraneous language and no liability waiver can be used in these forms. Also, the candidate must sign these forms before you do a background check. And the forms must also be solely of a disclosure and authorization. If you look below in the blue writing, you'll see these are just some of the lawsuits of non-compliant forms. So for example, Delta at 2.3 million, you have Uber at 7.5 million. These are just some of the lawsuits, and also why it's very, very important that your forms are compliant at the federal and state level. So, you know, what is the solution for this? You want to make sure that you're using compliant and separate disclosure authorization forms. You want to make sure that you keep these forms pure of legal language with no additional extraneous language. And these can also be automated as long as you're following the requirements. And then another area you can experience risk is the summary of rights. So Summary of rights is a document that lets a candidate know what their rights are under the FCRA. You want to make sure that you give the candidates a copy of their rights up front. This is federal law. There also have been some revisions to this. It was revised in 2018. The reason why it was revised was because there were high profile breaches and national security freezes. This is also where lawsuits came from because they weren't using the correct forms. It's also been revised again, and this is effective March 2024. The revisions included minor changes like addresses, agency names, but the basis of the form has not changed. It also solely has to be of the rights document. And if you click under the word revised or rights document, you'll see more information on this information as well. Solutions for this, you want the summary of rights form provided. You want to make sure it's provided when giving the disclosure and authorization on its own form. So you want to make sure that it's separate. You also want to provide the summary of rights form during the adverse action process, both pre and final. And you want to make sure that this is not stapled to any other documents.
Yeah, that's the craziest thing. They had a lawsuit because it was stapled to another document and said it wasn't solely the disclosure. So yeah, not even staples.
And then the adverse action process is another area you can put at risk, that can put you at risk. This is federal law under the Fair Credit Reporting Act. And it's a law in and of itself, it's a good law, right? It's going to give people the right to dispute incorrect information, which is fair. But this will essentially, the process will help determine like denying employment, terminating employment, denying promotions, transfer, etc. So why does the law require this process? It's to provide the opportunity for the consumer to dispute any information that may be incomplete or inaccurate, such as identity theft, common limited identifiers, and human error. And this is a pretty easy process. There are just 4 simple steps. You want to make sure that before taking any adverse action, you want to notify the consumer. You want to provide them a copy of the report. You want to provide them a summary of the rights. Even though you're giving this to them in the beginning, you want to give this to them during this process as well. And then you also want to wait a reasonable amount of time for them to dispute.
So we have another Slido question, just really quick. We'll make this fast. What's reasonable? 5 days, 7 days, 10 days. And that's what I was talking about with the California Fair Chance Act. At least they gave some specific timeframes. We were sharing this information with at a conference, and a gentleman raised his hand and he said 3 days isn't long enough. And I was like, oh no. He goes, oh yeah. He'd only waited 3 days and that lawsuit cost him $30,000. So they're very serious about making sure timeframes are followed, which is why it's frustrating when they don't give a specific day and they say reasonable. So what do we think? 5, 7, 10, pretty split across the board. Bounce around a little bit to 7. So it's kind of a trick question. Because it's reasonable, it doesn't say specifically how many. Case law says absolutely minimum of 5 days. But then when California comes into play, you're talking 10 days. Best practice is 10 days. We do have some clients that wait 7, never do less than 5. But again, if you're in California, it depends on the time starting from receipt of information. So you count 5 days for mailing, things along those lines. So again, best practice is 10 days. When it comes to how long you wait before you actually take action.
And the final adverse action forms, if the candidate does not dispute within the reasonable amount of time, then you want to make sure you send the final adverse action notice and provide a copy of the report as well, in addition to a copy of the summary of rights. And then you also may rescind the offer. In regards to the disputing process, if they dispute, the candidate is going to reach out to the background screening firm, and the background screening firm is tasked with solving the dispute. So the background screening firm then has 30 days to reinvestigate the case, and you have to hold the requisition open for 30 days. And then at that point, the candidate will be notified. If there was misinformation, then we would update the report. But either way, we would let them know the findings of the dispute.
Right, so this dispute process is pretty interesting. Again, just some things that have happened over the years. We had one case where we had identical twins, and one was a good son, one was a bad son, and the bad son kept using the good son's name, and it was very challenging for him. So every time it happened, he'd have to go in, they'd do prints, they'd compare, and he'd get off his record, but it was a pretty challenging arena. We did actually have a case where a client was going to give someone a second chance, and the person said they had alcohol-related vehicular manslaughter. However, when we did the report, it didn't come back as that, and candidate was very adamant that it was that. So at that point, your background screening firm is going to go and pull the whole case and read the whole thing. And at that point, we found out that his vehicular manslaughter took place inside a bar where he stabbed someone 27 times. So again, it's good to have your background screening firm as the one that should be dealing directly with your applicant. It keeps you safe. It makes it very clean. It's a third party. And the dispute process, again, they have 30 days by federal law. We have 30 days to complete it. Most of the time, we usually have it done within a week or two. Okay. So just kind of a review then of solutions as to what we were talking about as to some of the challenges. You're going to want to start your background screening process as soon as possible, because you have to take into chance the ban the box, the fair chance laws, conditional job offers, all those kind of things. You want to have a streamlined process with your requesters so that they understand how to get that time frame moving as fast as possible. The other thing you want to do is increase your efficiencies with technology. So an applicant tracking process, a candidate-driven process, all forms signed electronically, pre-populating as many fields as you can, just to make the process and the candidate experience as pleasant and as quick and as easy as possible. And you want to give clear instructions to the candidate. Sometimes they get that email or that text and they say, oh, well, excuse me, they're moving forward with me. That's great. When I go in for orientation, I'll do what I need to do. So you want to make sure that you give a strong emphasis that this has to be done as the next step, or we're not moving forward. Something along those lines, wording that will definitely make sure that the candidate understands the importance of doing it as soon as possible. And another thing you want to do is you're going to want to review the packages that you have to make sure you're just doing what's essential for that particular job. Your screening firm should allow you to have multiple packages. So you may not want to have, if someone is going to be a janitor, you might not need that education verification at the college level, or some positions might need that high school diploma. Some other ones don't. So you just want to make sure that your packages are concise versus just one package for everybody, if it doesn't really need to be that way. You're definitely going to talk to your legal and consult with your screening firm before making package changes. But again, if you want to make sure that essential searches are being done for that particular position. So I want to thank you for letting us present here. And now I'd like to open up if there's any questions that came up.
So I have 4 of them. What about gross negligence pertaining to the recidivism rate in crime? I hope I pronounced that correctly.
Could you repeat it one more time?
It says, what about gross negligence pertaining to the recidivism rate in crime?
Okay, so the hard part with that is I think gross negligence, well, first of all, obviously going to talk to your attorneys and they're going to set those guidelines for you. But when it comes to going to court, I think if you can show that you have screened what you're supposed to screen at the level you're supposed to screen, you've done all that you can do. And if there's laws that prohibit you from, or reasons that you have missed cases, or the person had criminal history that didn't show up because you didn't screen, that would be different. That would be the gross negligence for not having a good best practice in place versus having a good best practice in place and then something falling through the cracks. It is astounding to me with the technology that we have that background screening is as fragmented as it is. Every county maintains their own records and they don't share information. So you can search Los Angeles County and the person cross into Riverside County, commit a crime, you miss it, you're not going to see it. But if you searched Riverside where they've lived and you follow best practices, then when it comes to you couldn't know about that case, nothing told you to search. There's 3,300 counties. You can't search every county in the US. I think that that's where the courts would step back and look, did you do what was reasonable to try to prohibit any kind of criminal history or any kind of bad outcome from someone who you've hired? I hope that answers the question.
So the next one is, can we ask for salary expectations?
That's something you would check with your legal, and it would depend on where you live. I mean, really, it's that fragmented.
Can you ask on an application if they've been discharged from a previous employment for misconduct?
That I think would also depend on the individual jurisdictions as to what they would allow and not allow, and I would run that by your legal.
Does the conditional offer need to be in writing?
Yes.
And one that just came in, we have a new hire who did not pass our company background check. However, he was advised by our customer that they did own background check, which he passed. The customer wants us to hire him. How do we reconcile?
Okay, so your customer, well, first of all, the end user is the one who should be doing the background screen. So whoever's going to be writing the person's check is the end user. So if you're doing screening for somebody and you're not the end user, that's probably not a good idea. The end user is basically whoever is hiring the employee is the one who should be doing the check. As far as the employer who wants to hire them, I'm not sure what the scenario is here, but if you would be assuming the liability if the person behaved improperly, if they committed some crime or something bad happened at that point, I would check with your legal, but it would seem to me that it would be risk over discussing with the client that you have standards that you're not willing to take that risk. Again, not knowing exactly what that scenario looks like, that would be the what I think best practice would be.
Can the offer letter include the Fair Credit Reporting Act summary of your rights as an attachment?
Oh, can the offer letter include the summary of rights? Yes, just don't staple it. You can give them a summary of the rights up front. And let me explain the thing about the summary of rights. This is interesting too. It's federal law. The law doesn't say when you hand them an application, you have to hand them a summary of rights. The law says in adverse action, you must provide them a copy of the summary of rights. However, best practice is to give it to them up front. We're kind of waiting for the lawsuits to follow for those that don't. So it's just been kind of an industry standard to provide the summary of rights up front if you're going to do any kind of a background screening. So it's just saying, I don't know that you can over advise what their rights are. I would say that giving them a summary of rights up front with conditional job offer would be fine.
Great. I think if anybody else would like to ask a question, they could unmute.
Yeah, absolutely.
Hi, I just wanted to, I'm the one that asked about the conditional offer letter and attachments. So we actually include that Fair Credit Reporting Act, summary of your rights, and then the Los Angeles City notice to applicants and employees regarding FICO post offer as a PDF. And then we have an additional post offer criminal questionnaire that our in-house counsel created. Can we include that like as an attachment with the conditional offer letter, or do we need to wait until the conditional offer letter is signed to then send the post offer questionnaire? Like, because we do also, in addition to that, like through a third party background check.
Right. You know what? I would check with your legal on that as far as the timing is concerned. I don't know if the conditional, I would check with your legal. To me, the conditional job offer would be signed first before I would move forward with the asking about criminal history. I'd want that in my possession just because it would be safer. Again, your attorney may feel differently, but it just seems to me that I would do the conditional job offer when the offer comes back and it's signed. Or in the process, if they sign the offer, once they sign the offer, the next, if you're doing it electronically, then the criminal information pops up, or the questionnaire about that pops up. But I think best practice would be to get that signed first. Again, I'm not legal, but I would check with them and let them know what your concerns are and see what they have to say.
Okay, and then just in addition to that, the way that we do things, here's the hiring manager will do a verbal offer and then they notify HR and then we email the conditional offer letter with those attachments. So, okay, that's fine. Okay, great. Thank you.
You're welcome. Good questions, you guys. Thank you so much.
Another question came that says, can we have the applicant complete a background check form during the application process?
I would say not in California at this time. I think it's a conditional job offer first, not during the application process. That would be along the lines of the ban the box. Are you, wait, let me take that back. Are you having them sign permission to do a background check? Is that what you're talking about, those forms? But you're not actually running the check yet. You can unmute. I can.
Yeah.
Hi, my question was in regards to just the background check form. So just like the information that we ask is the name, the birth date, social security, and then their driver's license number and their address, but we wouldn't complete the background check until like we have we know that we're going to hire them, so we can have a bunch of their forms, but we would only run the background check on who we hire.
Right. I think that that's okay. Again, everything, because the lawsuits are so crazy. I don't know that has been challenged. Let me take that back. That hasn't been challenged in court yet, that we're aware of. So providing the forms is the simple fact that they're signing a form saying that you're going to do a background is not asking whether or not they have criminal history. It's just letting them know that you're going to be checking. So I don't think that there'd be an issue with providing those forms up front.
Okay. Thank
Actually,
you.
running the report would be not good until you have a conditional job offer in place.
Yeah, we wouldn't
That's just prepping for everything.
run the background until we only run the background check for who we offer the position to, and that would be during the job offer process.
Right. We're finding, and there's two schools of thoughts with that. The majority of our clients are doing the electronic forms for multiple reasons. Number one, they're time stamped, and a lot of screening firms offer the same thing, but they're time stamped. They can't say they didn't know that they didn't get it, like you didn't provide the correct authorization or whatever, and they can print them. And so we're finding that the electronic version tends to be much more risk reducing than the manual forms. Also, you don't have a paper that has someone's social security number on it that's accessible unless the file cabinets are locked and that kind of thing. Excuse me, but I do know that there are some people who say, well, they don't really have access to a computer, they don't have a smartphone, they can't fill it out. Most all forms are fillable now on your smartphone, but just something to consider. If it's possible to do it electronically, that's probably a better risk reducer than a manual form.
Thank you.
So any other questions from anyone here?
Yes, I have a question. Can you hear me?
I can.
Okay. On most of the background authorization forms that an applicant would fill out, I think a lot of them are driven by date of birth. So if they're including that and you're asking for that prior to a job offer, wouldn't that pose some sort of risk? Because
Yeah,
you're
that's
looking at someone's date of birth.
Yeah, that's kind of the concern with the manual forms. Having them fill that out up front is because you have a date of birth, and it is possible that they could come back and say, well, I gave you my date of birth prior to, so, you're really not hiring me because of age discrimination.
Right.
That's why the, I kind of more, because it's so available now, the electronic forms seem to be better. But yeah, I just think the conditional job offer signed in back first.
Okay.
And, because they have to sign the job offer anyway, it just would be a safer thing to provide that background screening form at the time the offer goes out.
Correct. Okay, thank you.
Sure. So again, just a couple things with that, social media searches too, just guys be really careful because it's kind of that catch 22. You know, you don't do it and you miss some things that you wish that you would have known about up front. But if you do it yourself, you got to be careful on what you see. So there's definitely social media searches out there that are safer. The THC testing, I didn't want to go too much into it. I wasn't sure what our time frame was going to be here. But the urine THC test cannot just show THC. The other drugs will show. Just so heads up, the labs are scrambling to come up with a urine test that will show only THC. I'm hoping to have it Q1. It's my understanding. Saliva test will show just THC, but the drawback on that is it will only show up if the person has inhaled marijuana. It doesn't show up on edibles. So it's kind of an interesting thing there, but just know the test, the urine THC test in and of itself is not illegal. You just can't use those results to make a hiring decision, but you certainly, it's can be used post-accident, on the job, that kind of thing too.
I have a quick question, if I may. Is LinkedIn consider a form of social media?
I would say yes.
Thank you.
Mhm. Hey, well, great questions, you guys. Thank you so much. It's been a pleasure sharing information with you. Last call if anybody else has questions. I see some chats here. I didn't look into those. I don't know if they've been looked at.
Yeah.
Already answered.
Okay, cool. I didn't know if that's where they're coming from. I have limited access here from what I'm seeing, so. All right, well, again, you're gonna get a copy of all of the slides. Oh, there are some questions. How does the employer provide a safe workplace for the non-drug users? The way that happens is you are allowed to have testing. You can also have, again, although it's not required, to have someone who is kind of along the lines of a field sobriety test. Someone who is able to identify those kind of things. I would imagine that we're going to see more and more training out there to help you identify someone who's under the influence. But yeah, if someone is showing reasonable suspicion, you can certainly have a drug testing policy in place that requires them to be tested if they're on the job and you have a reasonable suspicion of use of THC or any other drug for that matter. All right, so this is our contact information. Again, if I can be of any assistance or if we can be of any assistance, just reach out. We'd be happy to help.